the reservation as such, I nevertheless struck down those provisos and said that they were against Article 14 and something where it says when 50% should be women, you give, again you see, give it in one hand and take it by the other. And they are not working women. The vulnerability, marriage is one thing good. It is supposed to be a security for a woman who is not working. But the vulnerability is her right of residence in her matrimonial home must be protected. And secondly, a question is asked in certain organization as to when was their last period, because they want to know whether they are pregnant or not. Judiciary has played a key role in reinforcing the principles of representative governance. In this regard, I would like to highlight as to what was the position and what happened in Karnataka. In Karnataka, there is a very salutary provision which says that not less than 50% of the representatives in local bodies must be women. Very good. But what did they do? They added two provisos. The first proviso is that when it comes to the Adhyaksha and Upadhyaksha of local bodies, Zilla Panchayat, Taluk Panchayat, or you may call them chairman or vice chairman, or president and vice president, they said, the proviso said that two women simultaneously could not hold the post of Adhyaksha and Upadhyaksha. I found that strange, because if two men could, why not two women simultaneously? Then there was another proviso that one woman Adhyaksha or Upadhyaksha cannot succeed another Adhyaksha or Upadhyaksha. I found that also strange. Though those provisions were not challenged, the challenge was with regard to the reservation as such. I nevertheless struck down those provisos and said that they were against Article 14 and something where it says when 50% should be women, you give, again you see, give it in one hand and take it by the other. I observed, if the intention of the legislation is that 50% of the seats in Taluk Panchayat must be reserved for women candidates and 50% of the posts for chairpersons must also be reserved for women candidates, then the restrictions that two women cannot hold the post of chairpersons in a Taluk Panchayat simultaneously and two women cannot hold the post of chairperson consecutively, irrespective of the category to which they belong, are unreasonable restrictions and antithetical to the empowerment of women in a democracy, and particularly in the context of local self-government. Next, property is one of the important endowments or natural assets to accord opportunity, right to equal status and dignity of a person, particularly in a household or a family. Therefore, the Parliament enacted the amendments to the Hindu Succession Act in the year 2005. To this audience, I need not delineate on the Vinita Sharma case, where the Supreme Court held that Section 6 is retroactive and not prospective. Therefore, even if partition has taken place till the actual division of property by metes and bounds, on the basis of the amendment to Section 6, there could be a recalculation of the shares and for division of properties on an equal footing between the sons and the daughters. Of course, this provision has led to a lot of litigation, but I must tell that if the father, the brother, or the cousins, if they accept this provision, then automatically there would be no litigation. The daughter or the sister would not go to court. Therefore, the need is to implement this provision within the household and ensure that there is no litigation as such. At the same time, to balance, I may say this, where the daughters are very well off as compared to the brothers, then I think the daughters also must have a feeling and a heart for their brothers and not really insist on their pound of flesh. Another instance of this commitment towards women is the enactment of the Protection of Women for Domestic Violence Act, or the DV Act. When this legislation was under debate, the women MPs especially said that there should be need for democracy in our households. I had the privilege of authoring a judgment in Prabha Tyagi versus Kamlesh Devi, wherein Section 17 was interpreted as a separate right to say that a woman has a right of residence in a shared household, even in the absence of there being any domestic violence. I may say that when particularly young brides get married and they are not working women, the vulnerability, marriage is one thing good. It is supposed to be a security for a woman who is not working. But the vulnerability is her right of residence in her matrimonial home must be protected. And secondly, she must have some financial provision also made if she is not working. A woman cannot be expected to only save from the family budget for her own expenses. In Prabha Tyagi, I said that the right to reside must not be conditional upon the existence of domestic violence. Given the social reality of dependence of women, especially young brides in their matrimonial family, on shelter and finance if they have no independent source of income. There is no gainsaying that fact that most enduring protection against economic exploitation within households is the financial independence of women. I often say that women can get into formal workforce but are often hindered from getting up in the profession, just as in the legal profession, due to lack of sharing of household duties and responsibilities and bringing up of children and in performance of domestic chores. In 2023, the Global Gender Gap Report pegged the gender gap score at 68.4%, and it said that it would take 131 years to equalize earnings between men and women at the current rate of progress. Though we have the Equal Remuneration Act 1976, it is very difficult to ensure that the women get the equal pay as that of the men. This was the problem which arose in McKinnon-McKenzie versus Audrey DeCosta, and where they said that the Equal Remuneration Act could not apply because the justification of that company was the pay disparity is against female stenographers because their work was within inverted commas confidential, was not a valid reason for paying less, and it was a valid reason because they were taken as confidential private secretaries, and therefore they need not be paid more as compared to the male stenographers. That was struck down. But unfortunately, the Supreme Court in the late 70s and early 80s in Narges Mirza and Air India Cabin Crew Association versus Yashashwini Merchant tried to say that in the interest of family planning, a woman air hostess must not get married within the first 4 years of her marriage and must not get children within the first 3 or 4 years of her marriage, and there were many other kind of restrictions which were actually upheld by the Supreme Court. In my humble view, those judgments would call for a course correction. On the other hand, when it comes to maternity benefits, the courts have been very liberal in ensuring the bargain is struck between the motherhood and employment. In this regard, I must say two things. Especially women in the unorganized sector or the private sector, once they join the organization, then the question is, a question is asked in certain organization as to when was their last period, because they want to know whether they are pregnant or not. In case they are pregnant, they know that they are bound to go because of maternity leave. In such a case, why should we appoint such a woman? The second thing is, if a woman asks in the private sector for maternity leave, then when she returns, her job is already taken by somebody else. So when she has a child, it means she loses her job. That cannot be the situation. In Inspector Mahila Ravina versus Union of India, the Delhi High Court said that a female inspector was entitled to her promotion and her participation in the pre-promotion course, which was delayed on account of pregnancy, could not be held against her. When I was in the Karnataka High Court, we had a case where a judicial officer was asked to take oath on a particular day because she had passed in the recruitment. And she came on that day and met the Registrar General of the High Court and said, "Sir, any day I am due. The delivery date is fast approaching. I do not know whether I can come and take the oath on that day." And she was right, because she couldn't come and take the oath on that day. She had already delivered the child. Then my male colleague said she should lose her seniority because she did not take oath on that day, and her merit must give yield to her seniority, which she should lose. Justice Kamal Mukherjee was the Chief Justice. I insisted in the full court that it cannot be, because the statutory principles have to yield to Article 15(3) and Article 21 more importantly. And I raised my voice, and Justice Mukherjee, in fact, he was shattered. He said, "All right, sister, if you want, I will go to the nursing home and give the oath." I said, "If you are doing that, I will accompany you." That was a very good thing. But the lady saved the Chief Justice from going to the nursing home to give oath, because on the 5th day after her delivery, she came and took her oath in the Chief Justice chamber, and more importantly, she did not lose her seniority. These are the small ways in which judges can help women. And recently, I'm told, just last month, a lady who was 8 months pregnant, she asked for writing her exam for the judicial recruitment, I think the civil judges exam, from her hometown, because she couldn't travel after 8 months. Again, I am told there was a big controversy whether to permit her or not. Ultimately, thank God, they provided a supervisor and she wrote her examination from her hometown. That is also a very good positive thing for women. The third aspect of my speech is initiator of social reform. I need not explain much about Vaishakha versus State of Rajasthan to this august audience. Shaira Banu's case with regard to triple talaq, and also Joseph Shine. Another important subject is with regard to the social dialogue and reform which has come up on the question of marital rape. Justice Lokur's judgment in Independent Thought versus Union of India, which has read down exception 2 to section 375 of the IPC, has raised the age of consent of married girls to 18, and that marriage cannot be a basis for discrimination when it comes to consent. Grant of due value and recognition to household work is another frontier of gender justice, where the judiciary has been leading a transformative conversation. Unfortunately, it is only in the case when a homemaker dies and it is in a motor vehicle accident that the determination has to be made as to what is the value of her work for her family, which is actually invaluable. Anyway, some kind of determination is made on the basis of the monetary value. The de facto responsibilities of women include mundane and essential household chores, including cleaning and laundry. A woman has to devote a certain duration of time, all days of the week, all year round, without any break, unless she has fallen ill or has other pressing obligations to address at the same time. Women are also obliged to perform caregiving duties, irrespective of their engagement in the public work sphere. Women also manage important miscellaneous activities, such as maintenance of bank accounts, planning meals, purchasing groceries, shopping, paying for utilities, sending invites for occasions, buying gifts for ceremonies, getting odd jobs fixed to optimize the family's well-being, all on a strict budget so as to save the family's finances. These are the aspects which must be taken with regard to the value of a woman's role as a homemaker, not necessarily when she dies and the determination is to be made on a monetary basis, but on all times to come. Thanks to the progressive jurisprudence emanating from courts across the institutional hierarchy, this unpaid domestic and care work for homemakers has come to be now counted, of course, as I said, only when a homemaker dies. Widespread perceptions persist that an ideal marriage is one between an educated and well trained man and a woman with the kind of education and background in domestic skills that would make her a good homemaker. Who is a good homemaker? One who does only the cooking, the laundry, and the cleaning, being punctual for others, or one who works out and works in both. Both women and men must realize that they are the pillars of the institution of marriage. Different pillars serve different but equally important purposes. No family can subsist without a healthy balance of economics or care work. A condescending attitude towards women in the family is the cause of the cracks, and domestic violence and infidelity are the outcome of the emerging cracks. Mr. Nariman always speaks about the right attitude. I would only say that the men must remove that condescending attitude towards women. I would like to emphasize now I would like to say something about women and marriage. Because personally speaking, I feel that marriage and family as institutions are important in India, and that is why we are sustaining as a society. I would like to emphasize that it is high time that the institution of marriage and family is protected and sustained in our country, and that its very sustenance is dependent upon happiness, comfort, and well-being of women, and everybody in the family must make concrete efforts towards that objective. Just as the erosion of the proper and just function of an organ of the state can have damaging consequences on the entire structure of governance, the erosion of the identity of women in the family, in whatever capacity it is bound to cause eventual breakdown of family and marriage. It is often said that behind a successful man is a woman, but I would say that behind a successful woman should be a family. If it is a mother's responsibility to provide necessary psychological and emotional support for a child's learning and education in all realms, it is equally the father's responsibility in that regard. It is also her children, including her male children's obligation to ensure her all-around well-being, especially the senior women in the family. In a lighter vein, I would say, it is said that a son is a son till he gets a wife, but a daughter is a daughter for life. Therefore, it is necessary for sons to look after their mothers when they get old and not ignore them for any other reason. Further, a narrow view of marriage between a dominating male person to a subordinated female cannot be any longer acknowledged. There cannot be subordination of women in a marriage. It is when men fail to realize that education and financial independence of women make them empowered and they cannot be dominated upon, that cracks develop in a marriage, leading to abuse, mudslinging, and separation. This vitally affects their children, who are victims of marital discord. It's high time that the men realize that education and financial independence would mean that they are empowered, and therefore the society should know how to treat an empowered woman. I would also like to emphasize that education and financial independence of women cannot result in a woman trying to dominate her husband. I am trying to balance here, or other male members of her family. Education should result in development of tolerance and resilience within the family and not lead to ego, vanity, and looking down upon others. Respect for other members of the family and cultivation of a sense of humility would go a long way in sustaining marriages and families. To be humble is not a sign of weakness. According to me, to be humble is a sign of strength and antithetical to arrogance. The path-breaking work of last year's Nobel laureate in economics, Professor Claudia Golden, speaks poignantly to the grim labor market outcomes of women in India. For this, intra-household dynamics have a lot to say about whether women work or not. Therefore, all it requires is a greater understanding between the spouses, and one should not always look at it as a sacrifice if a woman sacrifices her career or profession for the sake of the welfare of the family. A woman being a homemaker has to face several challenges, such as being punctual for others and having no spare time for herself. And if she is not recognized for all her commitments towards the family, I can only feel sad for the men. At the same time, spouses living in different families for the sake of work and meeting during weekends or holidays is gaining acceptance. This is owing to the women making their presence felt in their workplaces due to their knowledge and skills on the one hand, and the need for additional income for the family on the other. Such adjustments by spouses would go a long way for providing better education for children and having a higher standard of life for the family. Women have come a long way, but we are yet to reach a point where a woman, like her male colleagues or her husband, brother, or father, will be able to enjoy the satisfaction of having a secure, stable work life and a healthy family. Before I conclude, I must emphasize an issue that remains critical to improving the quality of judicial review and adjudication that we, the people, and more importantly, we, the women of India, deserve. There is an urgent need for all organs of the state, institutions engaged in the regulation and growth of the legal profession, and institutions engaged in legal education to work within their mandate to make the Indian judiciary more inclusive and diverse.